This is an important hearing on FOIA, or the Freedom of Information Act. When Congress enacted FOIA more than 40 years ago, the watershed laws ushered in a new and unprecedented era of transparency in government. And 4 decades later, FOIA continued to give citizens access to the inner workings of their government and to guarantee the right to know for all Americans. The right to know is a cornerstone of our democracy. Without it, citizens are kept in the dark about key policy decisions that directly affect their lives. In the digital age, FOIA remains an indispensable tool in protecting the people's right to know. And as Americans from every corner of our nation commemorate Sunshine Week, they have good reason to cheer. I'm pleased that one of President Obama's first official acts when he took office was issue an historic new directive to strengthen FOIA. Just yesterday, the Department of Justice launched a new FOIA.gov website. It compiles all the department's FOIA data in one online location. The Congress has made good progress in strengthening FOIA. Last year, the Senate unanimously passed the FASTER FOIA Act. That was a bill that Senator Cornyn of Texas and I introduced to establish a bipartisan commission to study FOIA, to make recommendations to Congress in ways to further improve FOIA. And we will reintroduce this bill later this week. The reason Senator Cornyn and I have joined together for years now on strengthening FOIA, we go on the assumption that no matter whether you have a Democratic or Republican administration, whoever is there is going to be glad to talk about the things that go right, not quite so eager to talk about things that might not have gone right. And it helps everybody, no matter whether it's a Republican or Democratic administration, to know that the people being represented have a chance to find out what's happening. And there's reason to cheer the recent unanimous decision by the Supreme Court in Federal Communications Commission versus AT&T, concluding that corporations do not have a right of personal privacy under the Freedom of Information Act. And that, again, makes our government more open and accountable to the American people. Government is still not as open and as accessible as I'd like to see it, and many of us would. The implementation of FOIA continues to be hampered by the increasing use of exemptions, especially under Section B3 of FOIA. Last year, Senators Grassley and Cornyn and I worked together on a bipartisan basis to repeal an overly broad FOIA exemption in the historic Wall Street Reform Bill. But it's also essential American people have a FOIA law that's not only strengthened by reform, but properly enforced. A report released yesterday by the National Security Archive found that while there's been some progress in implementing the President's FOIA reforms, only about half of the federal agencies surveyed have taken steps to update their FOIA guides and FOIA resources. And FOIA delays continue to be a problem. 6-year-old delays are far too much. So I'm pleased we have representatives from the Department of Justice, the Office of Government Information Services, and I will continue to work with Senator Cornyn, Senator Grassley, and others, because this is something we should all join on. It's important for the country. Senator Grassley.
This is a very important hearing, and thank you for it, and particularly coming during this week that's called Sunshine Week, observed annually, seemingly coinciding with James Madison's birthday, founding father of our checks and balances system of government. Open government and transparency are more than just pleasant-sounding words. They're essential to maintain our democratic form of government. FOIA is based on the belief that citizens have a right to know what their government is doing and that the burden is on the government to prove otherwise. It requires that our government operate on the presumption of disclosure. So it's important to talk about the Freedom of Information Act and the need for American citizens to be able to easily obtain information from their government. Transparency is not adequate even in a Republican administration as far as I'm concerned. Although it's Sunshine Week, I'm disheartened continuing the practices of previous presidents, Republican or Democrat, that we don't have the openness that we should. And contrary to President Obama's hopeful pronouncements when he took office more than 2 years ago, the sun still isn't shining on the executive branch. Given my experiences in trying to pry information out of the executive branch and based on investigations by the media, I'm disappointed that President Obama's statements about transparency are not being put into practice. Federal agencies under the control of his political appointees have been more aggressive than ever in withholding information. There's a real disconnect between the President's words and the actions of his political appointees. On his first full day in office, President Obama issued a memorandum on FOIA to heads of all executive agencies. Quote, "The government should not keep information confidential merely because public officials might be embarrassed by disclosure, because errors and failures might be revealed, or because of speculative and abstract fears," end of quote. But further quoting his instruction to executive agencies, adopt a presumption in favor of disclosure, and that's very important to remember those words. Adopt a presumption in favor of disclosure in order to renew their commitment to the principles embodied in FOIA and to usher a new era of open government. Unfortunately, based upon his administration's actions, it appears that the eyes of the President's political appointees, his hopeful words about open government and transparency are mere words. It's not just a matter of disappointment in the administration's performance in complying with requests for information, and it's not even about bureaucratic business as usual. It's more and far worse. Perhaps the most dramatic and troubling departure from the President's vow to usher a new era of open government are revealed in emails from the Department of Homeland Security obtained by Associated Press July last year. A report by Ted Brittis of AP uncovered that for at least a year, Homeland Security was diverting requests for records to senior political advisors who delayed the release of records they considered politically sensitive. The review often delayed the release of information for weeks beyond the usual wait. Specifically in July, Department of Homeland Security introduced a directive requiring a wide range of information to be vetted by political appointees, no matter who requested it. Career employees were ordered to provide Secretary Napolitano political staff with information about the people who asked for records, such as where they lived, whether they were private citizens or reporters, and about the organizations they worked for. If a member of Congress sought such documents, employees were told to specify Democrat or Republican. The Homeland Security Directive laid out an expansive view of the sort of documents that required political vetting. Anything that touched on controversial or sensitive subject that could attract media attention or that dealt with meetings involving prominent business or and elected leaders had to go to political appointees. I was very disturbed by the Associated Press report, which came out July 21st last year. Accordingly, in August, Representative Isa and I wrote the Inspectors General of 29 agencies and asked them to review whether their agencies were taking steps to limit responses to Freedom of Information Act requests from lawmakers, journalists, activist groups, and watchdog organizations. The deadline for responding to my letter passed about 5 months ago. To date, only 11 of the 29 agencies have responded. The lack of a response from so many agencies send disturbing messages. The leadership of the federal agencies don't seem to consider the political screening of requests under the Freedom of Information Act to be a matter worthy of their attention. My concern about the lack of responses to my letter was well-founded. It now appears that the Department of Justice may have also politicized compliance with the Freedom of Information Act. February the 10th, 2011 blog I've got 3 more pages, and I'm laying out a case here. If you don't want me to, I'll put it in the record.
No, go ahead and finish that. Just want to get to the
On February the 10th, 2011, blog posting Christian Adams, a former attorney in the voting section of Civil Rights Division at the Justice Department, discussed this disturbing development in detail, specifically Adams's review of voting sections logs for Freedom of Information Act. Requests reveal that requests from liberals or politically connected civil rights groups are often given the same day or expedited turnaround. By contrast, requests from conservatives or Republicans face long delays if they are fulfilled at all. Adams reported that as of August 2010, the logs show a pattern of political screening and politicalizing compliance. Overall, the data in the logs obtained by Adams reveal priorities of the Civil Rights Division: transparency for insiders and friends, stonewalling for critics, political appointees, and Republicans. So, there is a disturbing contradiction between President Obama's words and the actions of his political appointees. When the agencies I'm reviewing get defensive and refuse to respond to my request, it makes me wonder what they're trying to hide. Throughout my career, I have actively conducted oversight of executive branch regardless of who controls Congress or who controls the White House. It's our constitutional duty. It's about basic government, good government and accountability, not party politics or ideology. Open government is not a Republican or Democrat issue. It has to be, and our chairman has highlighted that, a bipartisan approach. Our differences on policy issues and the workings of government must be debated before our citizens and open. I know I know that you know this, Mr. Chairman. I know how hard you worked with Senator Cornyn on the Open Government Act of 2007, which amended FOIA. Mr. Chairman, I hope that you and I are disturbed, or that you're as disturbed as I am by these reports and by the Attorney General's approach to them. I hope that you will work with me to investigate these allegations. I also hope that more in the media will investigate disturbing reports. I'm disappointed that there hasn't been more media coverage of the Associated Press uncovering the political screening of the Freedom of Information Act request by the Department of Homeland Security and Christian Adams's article about similar conduct at DOJ. I'm also disappointed that there has not been more coverage of Representative Ice's efforts to investigate Homeland Security's political screening of information requests. This conduct isn't just political decision-making, it's the politically motivated withholding of information about the very conduct of our government from our citizens. In particular, it's the withholding of information about Obama's administration's controversial policies and about its mistakes. We cannot ignore or minimize this type of conduct. It's our job in Congress to help ensure that agencies are more transparent and responsive to the government we represent. I view this hearing as a chance to have the facts come out and as a chance to examine some of the disturbing practices which have been reported on. In other words, as I sum it up, except for national security and intelligence information, and that's about 1% of total federal government's business, 99% of what the government does is the public's business, and it ought to be public. Thank you very much.
Thomas Fitton. He's the president of Judicial Watch, a public interest group that is set up to investigate government corruption. He's been affiliated with Judicial Watch since 1998. He is a former talk radio and television host and analyst. He's the author of several published articles. He also previously worked at the International Policy Forum, Leadership Institute, and Accuracy in Media. Mr. Fitton earned his bachelor's degree from George Washington University. Mr. Fitton, welcome. Please go ahead.
Thank you, Mr. Chairman. Thank you, Chairman Leahy and Senator Grassley, for hosting this hearing. It's an honor for me on behalf of Judicial Watch to appear before this committee, and I want to take some time to extend personal thanks to you both, the Chairman and Senator Grassley, for not only your leadership on government transparency, but your often unheralded work on behalf of government whistleblowers. You helped at least one of our clients many years ago, and I'm sure you've helped many other whistleblowers over the years. and these brave folk are often alone in their efforts to expose government wrongdoing. So your help is crucial and has been crucial to saving jobs and careers. Essential to Judicial Watch's anti-corruption and transparency mission, obviously, is the Freedom of Information Act. We're probably the only group on the right that uses it as the way we do. We've used this tool effectively to root out corruption in the Clinton administration and to take on the Bush administration's penchant for improper secrecy. We have nearly 17 years' experience using FOIA to advance the public interest, and without a doubt, we're the most active FOIA requester and litigator operating today. The American people were promised a new era of transparency with the Obama administration. Unfortunately, this promise has not been kept. To be clear, the Obama administration is less transparent than the Bush administration. We filed over 325 FOIA requests with the Obama administration, and we've been forced to file 44 FOIA lawsuits to enforce the law against the Obama administration. Administratively, Obama administration agencies have built additional hurdles and stonewalled even the most basic FOIA requests. The Bush administration was tough and tricky in this area, but the Obama administration is tougher and trickier. And once we're forced to go to federal court, the Obama administration continues to fight us tooth and nail. The Obama administration's litigious approach to FOIA is exactly the same as the Bush administration's. So one can imagine the difficulties we encounter litigating these issues in court against the Obama Justice Department. You know, we've been investigating the bailouts, as particularly Fannie and Freddie, trying to find out about political contributions and other key documents. The Obama administration has taken the position that despite the fact that Fannie and Freddie putting taxpayers on the hook for trillions of dollars, including over at least in the current number is $153 billion in funds expended for Fannie and Freddie. The Obama administration has taken the position that not one of those documents is subject to the Freedom of Information Act. These agencies have been taken over completely by the Federal Housing and Finance Administration, and yet they say none of these are agency records, nor will they be subject to disclosure. And we're at the appellate stage on that in terms of litigating that. In addition to walling off the control of our nation's mortgage markets through Fannie and Freddie from public accountability, the Obama Treasury Department has been seemingly incapable of disclosing even basic information on the various government bailouts. So I can't quite fathom how this administration can laud a new era of transparency while over $1 trillion in government spending on the bailouts is shielded from practical oversight and scrutiny by the American people. You know, this committee may also be interested to learn the truth behind the Obama White House's repeated trumpeting of the release of Secret Service White House visitor logs. In fact, the Obama administration is refusing to release tens of thousands of visitor logs and insists, following a Bush administration legal policy developed at the end of the administration, that they're not subject to the Freedom of Information Act. Obviously, the Secret Service is part of the Department of Homeland Security. Those records are subject to the Secret Service, to the Freedom of Information Act. In 2009, we were invited to the White House to visit with Norm Eisen, then Special Counsel to the President for Ethics and Government there, to discuss Judicial Watch's pursuit of these visitor logs. And we were told by the Obama White House in no uncertain terms that they wanted us to publicly encourage and praise them for being transparent, saying it would be good for them and good for us. Well, they refused to release these records as they're supposed to us under FOIA, and we were forced to sue in court. On top of this, we have the issue of the idea that now White House officials are meeting across the street at the White House Conference Center and in Caribou Coffee with lobbyists and others to avoid disclosing their names under this voluntary disclosure policy they've put out related to visitor logs. So rather than visiting people at the White House where their names might be subject to disclosure, they're meeting outside the White House. How does that comport with the President's commitment to transparency? We've been reading about the 1,000 plus Obamacare waivers that have been issued by the Department of Health and Human Services. We have yet to receive one document in response to our request and now lawsuit after 5 months about any of those waivers, not one document. And my final example briefly is the Department of Homeland Security. We had asked for a report about this illegal alien who was accused of running into and killing a nun. The report was sent to, according to reports, to the Department of Homeland Security Secretary Napolitano last year. We asked for this final report. They said, we'll give it to you. And then they said to us in the court, by the way, that report's not final, it's draft, and you can't have it. We're still working on the final report. Well, we just got it last month, and the report was dated November 24th. That, to me, is an indication that ham-handedness, only political appointees could be involved in that sort of process. So that's the concerns we have.
You did get the report.
We did get a report dated November 24th, but I don't know how a report dated November 24th could still be being worked on in January, February, March.
I want to make sure you understood that.
That's right.
I'm sorry you haven't been able to get the records of the visits during the Bush administration, and I wasn't able to either. So,
including that in year 2, the administration's performance was mixed and that it was struggling to fulfill the president's promises on transparency. First question, very briefly, based on your firsthand experience, do you agree with the evaluation of the Obama's administration performance in the first year, which was rated at C or lower?
Yes, I would give it a failing grade.
Two, how would you grade the Obama's administration performance during the second year?
It's still failing. To be specific, we appreciate the increased availability of government material on the internet, but about matters of public interest and controversy, in terms of getting information from the administration, it is as difficult, if not more difficult, than ever.
You're familiar with Tom Fitton's investigative report for AP. According to the report 2009 and 10, the Homeland Security diverted requests for records to senior political advisors who often delayed the release of records they considered politically sensitive. The political vetting often delayed the release of information for weeks beyond the usual wait. According to AP report, Homeland Security rescinded the rule prior political approval July of last year. Supposedly under new policy, records are now submitted to the Secretary's political advisors 3 days before they're made public, but can be released without their approval. Based on your experience, are President Obama's political appointees still engaging in politicized approach to handling requests for information under FOIA and to litigating lawsuits under the Act?
Yes, and certainly our experience with the Department of Homeland Security is consistent with that, specifically the release of this final report that became a draft report, that became a report in progress, that became a report that was finished in November of 2010.
Expand a little bit on your experiences. How widespread is the politicized approach to requests for information under FOIA?
Well, you see indications of the politicization when the response makes no sense to you, where, as I say, with the DHS memo, where you're told that we're not even going to look for documents because nothing you're asking for would be subject to disclosure, so we're not going to bother looking. Or with frankly, the request more recently of the FBI files, we asked for the documents related to Ted Kennedy's FBI file, and we had to push and push and push. And the FBI was pushed back on us, and it turned out to be they did not want to release embarrassing information, and they ended up releasing it to us in the end, but it came after 9 months of fighting. And that, to me, was an example of the administration, for political reasons, withholding embarrassing information about, a recently deceased Friendly Voice.
Your organization has extensive experience with tactics employed in this administration by political appointees in handling FOIA. Based on what you have seen, do you believe an independent investigation is warranted?
Yes.
And if so, do you have any suggestions or recommendations on who should investigate politicized compliance with freedom of information requests and what parameters of that investigation might be?
Well, if you think the law is important, you would have an independent counsel of some type appointed by the agency or by the Justice Department. If you think the law is a law to be trifled with, that it's a big joke, which I think that's how it's been treated, administration to administration. The politicization of FOIA did not begin with the Obama administration, but we were told it would end, and it has not.
My last question, as I noted before, your organization has significant experience. What is your evaluation of the Office of Government Information Services? What is the general impression of the requester community about the Office of Government Information Services?
That agency may be helpful to non-expert requesters in terms of helping them with the FOIA process. We've used it a little bit to try to speed along certain requests, and we've been successful in that regard. But when you're in a fight with or a dispute with an agency, you're not going to rely on that because you can go to court and get what you need or have a finality as to what the dispute is. You're not going to get finality through this agency.
My last question is whether or not you've got any suggestions for improving the Office of Government Information Services.
Well, I wouldn't focus on another layer of bureaucracy. Personally, I would focus on the agencies and the political appointees and making sure that there's a commitment to FOIA. Our government, for better or for worse, depending on your point of view, is doing more than ever, and FOIA has not caught up with it.
Thank you so much for this sort of hearing, but it's something that you just kind of got to keep your hands on all the time if we're ever going to beat down these roadblocks.
Been doing it for over 30 years, and
I know it.
we'll continue.
All the more reason we got to work hard.
Senator Whitehouse and Senator Franken.
Were the panelists here when I asked my questions to the first panel? Could I ask each of you to respond, the topic being here we are in the Google age, the digital age. What are the best steps that we can do to make the FOIA banks more accessible to the public, even people who just don't want to file a FOIA themselves but just want to use it for research purposes?
Yeah, Senator, my prepared testimony and my statement this morning go into that in some detail. I think there are two large baskets that you should be looking at. One is information that ought to be automatically disclosed without resort to FOIA requests. The Obama administration's taken some criticism from Mr. Fitton. I don't think there's any question that has gone further than any administration in history in putting out information, particularly on recovery.gov, data.gov, and putting up useful information to the public. The Freedom of Information Act always had a provision that required certain information to be published as a pro forma matter. That's been expanded to include responses to FOIA requests in which people have, the agency thought that it would be requested again, so they put it out there. But that could be taken much, much further. So that's one area to explicit, and my written testimony goes into some areas where that might be particularly useful. A second area is that FOIA requests themselves, as a result of the legislation that was passed by the chairman and Senator Cornyn, there is now a requirement that FOIA requests get a docket number. The requests themselves can be published into a common database. The responses can be put into a common database. That would actually probably be a more productive way to process requests, would save money in the long run, and provide valuable information to the public.
Do you think that the notion of a search engine on FOIA.gov that can go through the websites of different departments is adequate?
Sure. I mean, no, I don't. I think what FOIA.gov does is to try to have a common set of policies, give people some better tools to basically interact with federal agencies on FOIA. But I think it could definitely go further. And again, I think recovery.gov is a good example in which if you put the data out there, people in the private sector will think of all kinds of interesting ways to utilize that data to create more productivity that can come from having open access to government information.
Ms. Cohen?
Yeah, there are a couple things. I think your thoughts on the searchable FOIA is excellent. I just want to mention that when we've been talking about these frequently requested records or common records, it is so inconsistent whether or not those are ever posted. I know that virtually every FOIA request I've ever made has never shown up on a government website, except when it was posted before it was responded to me. So those sites have a long way to go, but you do need a search engine to go through them. I think there must be several hundred of those sites out there. And the second thing that I've mentioned in my written testimony is to also spend some time administratively looking at the systems that are used to generate records. One of the real problems here is that the record system still can't be searched in a way that then produces an efficient system. so that the review of how agencies are redoing their record systems, I think, might include a review of whether or not there's transparency in those record systems built in, because there really isn't right now.
Mr. Fitton?
Yes, Senator, some folks specialize in FOIA-ing FOIAs. Give me the list of all the FOIAs and look for the juicy ones and then pursue those a little bit more. Obviously, putting out large swaths of information is good, and there has been progress in that regard. There has been some concern that a lot of the information, it was reported last week, was not correctly inputted. I think that's more of a matter of competency than anything else. But as I noted, it matters of public controversy. The Internet is not going to be where you find that. For instance, the decision whether or not to put Fannie and Freddie into conservatorship. We're litigating that right now. Decisions about the bailout, about why these decisions were made, the deliberative process type of decisions, that's where you get into disputes, and obviously that's where the interest is in terms of the public of matters of controversy or where there may be concerns about the decision making and what went into it. And that is unlikely to get onto the Internet. And if it does get onto the Internet, right now you're going to have difficulty finding it.
But it would at least enable the resources that these agencies have, limited resources, to respond to FOIA requests, to be dedicated to those more challenging ones that you're suggesting, rather than chasing around the day-to-day stuff, because that could be more readily accessed automatically. And so it would be even helpful in that sense to the more challenging requests, no?
That's right. For instance, the BP oil spill, many thousands of documents have been posted by the administration, appropriately so, on the Internet, and we've got them separately. So, but we're happy to, if we think they're there and we're confident that they're all there, that would be responsive to a particular request. We don't, believe it or not, we don't want to sue if we can avoid it, and we'd be happy to avoid litigation.
Thank you, and I'm going to turn the very valuable to this committee and
thank you.
To this area.
I came from Indian Affairs, and I just stepped out from some people from Minneapolis City Council to talk to them. So I think I'm picking up, or I may not even be picking up. I may just be repeating what Senator Whitehouse just said. So don't want to do that. But what the gist of what I think I heard, because I heard the last 15 seconds of Mr. Fitton's answer, is that if you put online pretty much everything, that I think the premise is that where you're going to put that Mr. Fitton's premise might have been, I'm extrapolating from the last 15 seconds of your answer, so is that if the administration just puts everything online, that they're still not going to put online some of the most controversial stuff, which is the kind of stuff that you want. Is that right?
I would suspect that.
That you would suspect that, and probably have a reason to, right?
Well, there are privileges that there are lawful reasons for withholding information, and
sure,
and often discretionary.
But
some administrations will be more willing to release information than others, and that's where litigation comes in.
But by putting on so much, and like in the BP thing, they put on stuff that was very helpful, right? They put up a whole BP site, basically, about the spill, right?
Right.
Okay, so that's very, very helpful. And then it sort of makes it more efficient to go after the more controversial stuff if everything else has been online. That's what you've been suggesting, Mr. Podesta, right?
That's right, Senator. And, I think that, as I said, the kinds of things the government might think of as...
And the chairman on their on whistleblowers. I think it's very important to protect whistleblowers. I was a little confused about the visitor logs at the White House and the Caribou Coffee thing. If they're not allowing the visitor logs, why would they go to Caribou Coffee?
Well, they are disclosing them voluntarily after, I think, August of 2009. Anything before that, you have to ask them specifically, and they may withhold information. The question isn't whether they're...
I'm sorry, I was very confused about that.
They're voluntarily disclosing the visitor logs, but they're saying that it's a voluntary disclosure. It's not pursuant to the Freedom of Information Act. During the Bush administration, we had asked for the visitor logs related to Jack Abramoff, And we were given those logs pursuant to litigation, but also pursuant to the Freedom of Information Act. Then the left started asking the Bush administration for more interesting visitors from their perspective. And the Bush administration said, enough of this, we're going to say that these logs are not subject to freedom of information. And the Obama administration continues with that legal position. The voluntary disclosure is subject to caveats. They can release, withhold names based on, for political reasons, that they're meeting with appointees or someone they don't want to be disclosed within a certain amount of time. So they know they're voluntarily disclosing this information, and then they're going across the street, or so it's been reported in the New York Times, at Caribou Coffee to avoid this voluntary disclosure. So they're saying they're not subject to disclosure under the law. The disclosure is voluntary, and that can be reversed either by this president or any subsequent president. So we're still in the position of trying to get information pursuant to the law, and we're unable to do it.
Senator, I think this is one of those examples of no good deed going unpunished. I think the administration has put more information about who goes in and out of the West Wing of the White House than obviously any administration in the past, including the one in which I served. And I think that, so Mr. Fitton's complaint is, and that's regularly updated. They did the process, I don't know, for the first 6 months in August of 2009, but now they regularly and routinely update who goes in and out of the White House. I think it will be difficult, although certainly not impossible, to reverse that decision and decide that particularly in this administration, but in subsequent administrations as well, to decide that the public doesn't have a right to know who's walking in and out of the West Wing of the White House.
Well, just briefly, the Office of Administration voluntarily complied with FOIA even though it did not think it was subject to freedom of information. And that changed under the Bush administration. We used to get material from the OA, from the Clinton administration and during parts of the Bush administration, and then they shut it off. And it hasn't been turned on again. It can stop.
Mr. Fitton and I could go on about this. I spent many quality hours before Judge Lamberth explaining what our information practices were in the Clinton White House with Mr. Fitton's predecessor at Judicial Watch. But I think that, and he did note that, I think good public practice comes into play, and presidents change and they can move in the wrong direction. But I'm not sure exactly what Mr. Fitton's recommendation is for resolving this particular controversy.
Well, I want to thank you both, and you can continue.
Cameras and Caribou Coffee.
I think you can continue the conversation in Caribou Coffee. Thank you all for coming today. The record will be held open for a week for additional material and questions. This hearing is adjourned.
Thank you, Senator.